Welcome to Case Closed, the Contingency Fee Podcast. On the show, our team of industry experts interviews contingency fee attorneys. You will discover everything from how they got started to the secrets of their success and what's working in today's marketplace. And now, here's the Case Closed Podcast.
Well, good morning. We have Emanuel Galimidi from Miami, Florida, who is a very prominent plaintiff's attorney. And we are on the Case Closed podcast. So, Emanuel, our job today is tell the world what you do and how good you are. And having read your background, you are better than I expected. They're booking really great people for me. So we're going to get right into it. What has been your highest professional moment in your cases?
Sure. I think two, and they're not necessarily related to particular cases. One I would say is a referral that I received from a former client. I was a defense lawyer, as you may have seen already, for about 20 years, and I received a referral from a former client on a particular catastrophic injury case, and they had any number of options to refer it to once I became a plaintiff's lawyer, and the fact that they referred it to me meant a lot. And I would say the second one is a little bit different. I had the pleasure of the opportunity of working with some really amazing people at my old firm, and seeing a couple of them become partners at the firm while I was there and kind of ascending and really meeting their potential was pretty awesome to see that and to be a small part of it. And so that brought me a lot of joy. Great.
What is the low that you've experienced in your practice?
I would say probably, and this is probably I was laid off from my first ever job. It was some budget cuts, what have you. And that was pretty disheartening. I was a very young lawyer, probably a first or second year when it happened. I think it was the second year when it happened. And so that was tough. That was tough on the ego and tough financially. So that was difficult.
How many cases do you handle today? Approximately?
Upwards of, typically they range between maybe 25 to 40 files, depending on, sometimes they're a little bit lower, but they're a lot more intense. They're a lot more fact intensive and a lot larger cases. So I won't take on necessarily as many, but yeah, between those two numbers is about right.
Do you focus on auto accidents, med mal, product liability? What is your focus?
Catastrophic injury is typically my focus, whether it's a motor vehicle accident or a product liability case. I've handled, everything kind of up the chain from a small auto accident all the way up to class action defense when I was a defense lawyer. So anything in that is well within my wheelhouse.
How do you get most of your cases?
I would say through referrals and through social media.
And how many attorneys would you estimate refer to you?
Oh, maybe half a dozen to a dozen, depends.
Okay. What is the biggest case you've had in dollars?
I can't really say specific numbers, but I would say in the tens of millions is the largest case I've handled.
And what's since you're dealing with catastrophic cases, approximately how many years does it take for resolution in most of your cases?
That all depends. It depends on the response you receive from the carrier, and it depends on the quality of defense attorney that they hire. Oftentimes you may have a very, very big injury case with clear liability, but if the right lawyer isn't on the other side, and by right lawyer, I don't mean went to the best school or anything like that, just more someone who understands how to value cases. If you don't have that person as kind of your first point of entry, and then, whoever the analyst is on the other side for the carrier, if they're not properly trained and they don't, fully grasp the extent of certain cases, then it can take a while. Now, on the opposite end of the spectrum, if you have people who know what they're doing, quite frankly, cases can resolve pretty quickly.
So of all, let's say you have an average of 40 cases for the audience's sake, how many of those cases end up where you file bad faith paperwork?
That doesn't happen too often. I wouldn't say it happens all that often. Most carriers these days are pretty well attuned, I would say, to the perils, especially in Florida, which is a hotbed, let's say, of bad faith litigation more than some other states based on how the statute is interpreted. So I wouldn't say not all too many. And oftentimes because by the time it gets to that point where there may be a valid allegation of bad faith, the right people have gotten involved. And when I say the right people, I mean people kind of further up the food chain at a particular carrier have gotten their hands on it and figured out, wow, we've got a problem here. And so I'll get a phone call from the right folks, and we'll work through it if we can.
Are you currently working on any class actions?
No.
Okay. Is that something that interests you, class action cases?
It is. It's like I worked on them before, but I don't have any pending right now.
Okay. To what do you attribute your success?
I would say perseverance. I would say that's the one thing that I would say is, most important for, at least for me, is just kind of pushing through even when things are difficult or you don't quite know how to, get one thing resolved or another. You just kind of push through, find the right resources to make it happen.
What is the best advice you have received, and from whom did it come?
Okay, so I wouldn't say it was definitely advice, but it wasn't given. It was something more that I observed and that I've tried to implement into my practice, most certainly, and into my daily life. This was probably, 15 years or more ago. I was working on a pretty large construction case. And for anyone who's watching, who's dealt with construction cases, you know that there's 15, 20 lawyers or more, depending on how big the case is. And I was a younger lawyer who, like a lot of lawyers, liked to talk. And I always thought I had something really smart to say. Sometimes that was true, and oftentimes it wasn't. But in any event, I remember being on all these conference calls and everyone just kind of yapping away and me just kind of waiting to get my turn to say something. And there was always there was one particular lawyer who was lead counsel for one of the bigger defendants, and he really wouldn't say anything. A deposition, he'd ask the questions he needed to ask, and that was kind of it. And in these conference calls, he'd say whatever he needed to say, but he never droned on. And I was like, man, what is this? What's this guy's deal? And anyway, the result ended up really favoring his client. And one thing I kind of picked up was he said what was necessary to say, and that was it. And it taught me the value of just not saying anything, and how that probably gave him, an opportunity to kind of think, to observe, and without really giving anything away, which a lot of lawyers tend to do. I realized as I've tried to incorporate that into my practice and into my daily life. So to answer your question, it wasn't so much advice he gave me, although he probably would have given it to me if he decided to say anything.
He gave it to you by operation of existence.
Right. So by me just kind of watching and realizing he was the one guy who really didn't say much and was in a position to say a lot if he wanted to, I learned. I'm like, this is a very effective way of practicing and of conducting yourself. So let's incorporate that. Now, am I always successful? No.
But I bet you tell that to every witness you prep for a deposition to be just like that attorney.
It is. And that's, witness prep is its own art and science. But yeah, so that's, I would say, the biggest piece of advice that I was given in a way that maybe a little untraditional.
What do you do? How do you market or get business from social media? That's very interesting because very few attorneys actually do.
Sure. I think it's important. Well, I have a YouTube channel that has some videos on it. I've done a little bit of work on Facebook and a little bit on Instagram. I'm kind of ramping up those efforts, but I've also posted on LinkedIn. I've gotten cases just by posting on LinkedIn. So it's really just trying them all out as best you can and not really worrying about impressions or how many people are seeing it or how many likes, because the reality is, at least in our line of work, we don't have to sell 30,000 t-shirts. You know what I mean? We just need to get, if you get one or two or three cases, whatever it is, you're not investing hardly any money, if at all, on social media, unless you want to kind of pump out advertisements or whatever. So the ROI on it is huge. Some of the biggest cases I've had since I began my practice have come from social media.
So have you ever tried the following? To set up a plan to identify general practitioners that you've never met and take them to lunch, do like the lunch patrol and meet 20 or 30 general practitioners each year and take them to lunch. Have you ever marketed that way?
What do you mean by never met? Just people I don't know, or?
Yeah, people you don't know. Have you ever gone out there to try and go to lunch with a whole bunch of different general practitioners you do not know?
No, because I just the mechanics of it, I'm kind of not sure what you mean. Just if I don't know someone, how would I invite them?
You just call them up and say, I'm Emanuel. I'm the greatest PI attorney ever, and I want to take you to lunch.
No, I don't think I've done cold calls like that. I mean, I do incorporate the part of, taking folks to lunch or breakfast or what have you. I do incorporate that as part of my networking. I do that quite a bit. I try and have at least 1 to 2 breakfast or lunch, what have you, meetings per week if I can. And I just schedule them way in advance. And so in case folks, can't make it, someone's kid's sick, whatever it is, or something comes up with me, I've got folks that are kind of that I'm waiting to call. So I call them and see if they're available. So I do it that way.
Okay. What are common mistakes you see other attorneys make?
And I'm pausing not because I don't see folks do things differently than I would, but I'm just trying to think of what the biggest one is. I would say in our profession is not keeping up with technology, because there are so many ways that legal tech specifically, can make life easier for lawyers. From everything from networking to client procurement to file management to everything. I mean, if you look at just Chat GPT, if you look at that, and that's only about maybe a couple months old, and there's lots of ways that lawyers can begin using that if they want to. So I think that's the most common mistake, irrespective of whether it's a first year or someone who's been doing it 30 years. I would say that's probably the biggest mistake.
So you agree that it's important for the bar to require all of us to have that extra 3 hours of technology education for our continuing legal education?
It's a bit of a leading question.
Of course, I'm a defense attorney. Of course, I'm going to lead a plaintiff's attorney.
So no, I don't know that I need the bar making additional requirements, creating additional requirements. I think that if lawyers want to succeed like any other profession, you're going to seek out the means and methods by which to do that. I don't know that I need additional CLE requirements.
So without mentioning any defense attorneys, what is the biggest mistake in the dynamics they try and interact with you with? How does the defense bar upset you by doing X, Y, or Z that inhibits the progress on a case?
I would say it's not even so much an interaction with me, but I would say not keeping the carrier, or if it's a self-insured, what have you, up to date and apprising them of any changes in the case, what have you. I kind of sound like a supervising defense attorney, which I was for so long, but that's really what the problem is that I've realized. When a defense lawyer is kind of gumming up the work, so to speak, it's because they're not updating the carrier, which doesn't allow the carrier to set their proper reserves, so that when my demand comes in, everyone's kind of running around like a chicken with the head cut off. And it's like, wait a second, my demand's coming in 60 days, 120 days after we started speaking, or whatever it is, where I sent my letter of rep. And now all of a sudden you're scrambling to get an eval out. And it's like, okay, look, I mean, my demand's going to expire whether your eval went out or not. And now I don't necessarily will know that as a plaintiff's lawyer. I don't have access to someone's calendar, but I can kind of tell, having done it for so long, whether they prepared the carrier and set the expectations for what's to come or what is here. So I would say that's the biggest obstacle. It's not any way of dealing with me. It's more, I know if you're not doing your job, and that's what's gumming things up. That's what's slowing things down.
Okay, so obviously when the defense attorney gums things up, it adversely affects your client. Do you think there's a solution that would allow you to cajole more successfully the defense attorney to properly and keep his client up to date?
Sure. I mean, I try and be as transparent as I can. Now, granted, not all plaintiffs' attorneys practice the same way. Everyone has different strategies, different things that have worked for them in the past. I try and be as transparent as I can with what I think is important for them, meaning the defense lawyer and the carrier, to value the case, because there's no sense in me, and this is something that used to tick me off all the time when I was a defense lawyer, there's no sense in me, going to mediation, let's say, and then all of a sudden, the night before, doubling my demand or finally issuing a demand, because now no one's prepared. And then what was the point of all that? So I would just say that being transparent as much as you can, obviously, because we all are tacticians and we all need to, disclose certain things at certain times. But for the most part, I would say being transparent, because that way, the defense lawyer knows, okay, I've got 500,000 in meds, or I've got, these adverse witnesses, and this lawyer already has affidavits. So now I can, when I'm updating the carrier, I know exactly how bad it is. And when we go to mediation, it's now on the carrier to have the appropriate amount of money.
Fantastic. How do you help the next generation of attorneys?
I'll use that word again, transparency. I try and explain first. I guess I try and teach by explaining the mistakes that I've made and saying, look, here's how I botched this. And depending if we're having a conversation with somebody, look here. Oh, I know what you're talking about. I actually had that situation. I botched it. Here's how, and here's how I fixed it. So I would say, a lot of times when I was kind of coming up, I looked at lawyers that were, even when I was a first year, they were like a 10th year or a 20 year or whatever it was. And I'm like, God, these people are amazing and they don't screw up and I can't screw up and I better not screw up. And it gave them an air of irrefutability. And it was just the opposite because everyone is human and everybody screws up and makes mistakes. The question is, how bad is a mistake and how often do you make it? That's really the only distinction.
And whether you make it early enough in that you can fix it.
Precisely. And so I think it's a matter of saying, look, I've made mistakes. Here's how. And, here's how I fixed it. Here's how I resolved it. Or here's how it took me a while to get it fixed because I didn't address it head on. And then those things become teaching moments for folks, for younger lawyers. And that, look, you're going to make mistakes. You're going to make mistakes that I never would have made. And I've made mistakes you'll never make, depending on personalities and whatnot. But here's how to resolve them and allow you to sleep at night.
Well, ladies and gentlemen, this has been another edition of the Case Closed podcast. If you want a great attorney in Miami, you better hire Emanuel. If not, you have to deal with me, the former defense attorney. Thank you very much for your time.
Thank you.
Thank you for listening to another episode of Case Closed, the Contingency Fee Podcast. We hope you enjoyed listening to this week's guests and their insight. If you liked what you heard, please consider subscribing wherever you listen to podcasts. Case Closed, the Contingency Fee Podcast, is led by industry experts who unlock insights from the nation's top contingency fee attorneys. Each week on the show, the guests share how they got started, secrets of their success, and what's working in today's marketplace. Guests on the Case Closed podcast include successful contingency fee attorneys that will share their secrets so you can close more cases. Tune in each week for a dynamic conversation about winning legal strategies that will grow your business.